It all started with fire and charcoal. Now we communicate with photons and pixels. Bill Gates once said, "I'm a great believer that any tool that enhances communication has profound effects in terms of how people can learn from each other." The art of communication has come a long way since the dawn of mankind, and thankfully, the tools of communication have progressed as well. Many of you have seen those tools populating our warehouse shelves, and in fact, many are present in this room here today. Several years ago, Steve Jobs was quoted as saying, "Great things in business are never done by one person. They're done by a team of people." Many members of those teams doing great things are also present in this room here today. Those of us who've made a commitment to be the best in what we each do, and a key part of that commitment is to continually educate ourselves in the latest techniques, technology, and information. In that spirit, StageRight is proud to be hosting a series of educational events to help all of us thrive in the ever-changing world in which we do business. So, ladies and gentlemen, let's get started.
Ladies and gentlemen, please welcome to the stage Scott Stedronsky.
Good afternoon, and thank you very much for coming. Welcome to StageRight. I am Scott Stedronsky. I'm one of the owners here of StageRight. I just want to take a quick second to thank you very much for attending the program. We know how valuable time is in the office, and I'm sure you feel just like us sometimes. There's not enough time in the day to get your stuff done. So to take a break and come out here, we, again, thank you very much for doing that. Without further ado, I think we got a great program here. So to get us started, I would like to bring up our Director of Sales and Business Administration, Jay Mooney.
Welcome, everyone, and thank you for coming out, especially on such a beautiful day. That's part of the distraction as well. I'm Jay Mooney, the Director of Sales and Business Development here at StageRight. So if you have any questions, needs, or have an event to book soon, see me after the event. Anyway, this is our second meeting on the topic of venue contract negotiation for meeting and event planners. And I'll state that it is not a rehash of the program we did 2 years ago. There's a lot of new ground to cover, and we're really excited about offering this program. If you happen to attend the first meeting or have seen it online, which we'll be posting this online as well, between these two sessions, you'll now have a PhD in the topic. Let's also not forget that this program, its content, has been approved for your CMP continuing education content. Let's do a little housekeeping here and talk about the AMS system that you see here. If you have your device, we are going to be doing some Q&A using these interactive devices. Use the number key to select your answer as we go along. So depending on the number of responses, you push the according button. These ARS devices also have a microphone. So what's great is at the end when we do Q&A, you'll actually push the microphone button down, and you'll hold it a few inches away. Don't do it like this. Speaking to it like a normal microphone. A little bit about these devices. If you're interested in, if you've never used these types of devices at your conference or meeting, you can push branding onto this, you can push content onto this, They're really, really useful at your conference or meeting. All right, let's get down to it. I'd like to introduce our guest speaker, Nathan Breen. Nathan is a partner with Howe & Hutton. Nathan's practice is concentrated primarily in association and intellectual property and internet law, including trademarks, copyrights, domain names, e-commerce, and privacy issues. Nathan also maintains a practice in commercial litigation, contracts, and hospitality law. And Nathan teaches courses in hospitality law as an adjunct professor at Kendall College. Ladies and gentlemen, Nathan Breen. Thank you so much.
Thanks, Jake. Appreciate it. My name is Nathan Breen. I've been practicing for almost 20 years in the field of primarily association and hospitality law. And did a program about a year and a half ago where we touched on a lot of event contract specific items. Today we're going to be focusing on negotiation, but with a specific emphasis on risk management. So we're going to talk about a wide variety of risks that can come up in the contract negotiation process and in hospitality and association law generally. First, though, let's talk about what we're dealing with here. Risk is defined as the possibility that something bad or unfortunate may happen. We get up every morning, we're dealing with that at some level, but we're dealing with that at a much higher level when we start talking about contract negotiation and taking on responsibility for claims that may come up and being responsible for damages or injuries or things of that nature. So fundamentally, let's talk at a high level about what we can do to manage risk effectively. The first, perhaps most obvious thing would be to avoid the risk. Sometimes things are just simply too dangerous to contemplate trying to deal with in any other way than simply just not going forward with a certain task that may be so likely to have a negative outcome that we're just better off staying away entirely. If we don't want to do that, then we need to use another form of risk management. We can possibly accept the risk. Now, this is an element that is always going to be present in a negotiation because if there is risk, one side to that transaction is going to have to accept it. So a well thought out negotiation involves allocating those risks between the parties in a way that makes sense. We can transfer the risk between parties contractually. We do that fundamentally with a concept called indemnification, which I'm going to refer to a few times throughout today's presentation. But towards the end, we're going to take an in-depth look kind of at what that means and why it's so important. We can insure the risk. This is a very important component of risk management, especially where there could be substantial claims that may arise, large dollar figures as far as damages go. We want to be sure that we're in a position to where our company doesn't have to absorb that, or even potentially we personally may be in a situation where there's some personal liability. We want to avoid that at all costs. Insurance is very useful for that purpose. We also want to think about getting releases and waivers from people that may have the potential for a claim. That's a way to use a contract to minimize our risk. So if we get people to understand and acknowledge any risk that they may be taking on, agree that they're not going to bring claims against us, that's also another important component of risk management. So those are our fundamentals. Now we're going to talk about a variety of specific topics involving risk management, how we can deal with that, how we can mitigate the risk, and how we can address that from a contractual standpoint as well. First thing we're going to talk about in that regard is managing liquor liability. This is first, perhaps because it's extremely important in that when people are becoming intoxicated at any level, their inhibitions decrease and they may not be making wise decisions. That elevates the level of risk substantially, which is why we want to be sure that we're doing everything we can to offset that risk. And from a contract negotiation standpoint, the equitable approach there is to allocate fundamentally the risk to the party that's benefiting from the sale of the alcohol in question. Those folks should be in a position to be able to control the sale. They're benefiting, profiting from the sale, and should have some kind of insurance that would cover claims that arise out of the sale. There's licensing issues too that would be at play, which all lend to the proper approach being that party should take on the risk. Specifically how we mitigate that risk, we want to have bartenders that are well-trained. There are programs out there, TIPS being the prominent one, that will ensure that you've got an adequate level of education and awareness in terms of mitigating any issues that come into the service of alcohol, whether it's over-serving someone or dealing with underage individuals or anything like that. We can use drink tickets as a way to mitigate risk. That's helpful. The only thing you got to worry about there is people like me that wander around and say, hey, you're going to use that extra? Next thing you know, I got 15 tickets. But it's better than nothing. We want to think about shortening, perhaps, receptions. Everybody would like maybe to drink all night, but the risk is going to go way up substantially if you have that type of a setting where there's access to alcohol for that long of a period. Serve food with liquor, always a good idea to give some folks something to eat so that they're not just drinking, and that's going to kind of help them as they metabolize the alcohol. Provide designated drivers or sleeping rooms if that's feasible. You could also incorporate, maybe Uber into this or some other form of transportation where you're offering your attendees a safe means by which they can get back from your event. Lastly, and not least, we don't want to allow staff to consume alcohol while working at an event. That would be a surefire way to set yourself up for a potential negligence claim. Talk a little bit about presenter or entertainer liability. This would be either spokespeople or keynote kind of presenters. This could involve bands or comedians or comedy troupes or anything like that. Anytime you've got somebody that's going to come and present material, you want to have some understanding as to what the expectation is there and how any kind of liabilities may play out as far as any claims that might arise. Communication is very important here, and part of that is doing your research, knowing what you're getting into in terms of a particular presenter, whether it's a political issue that you might be concerned about, or maybe some of the content of the presentation may be a little off color. Do your homework so that you're not putting yourself in a situation where there's any surprise in that regard. And part of that, too, would be to communicate the nature of the audience to the presenter. If this is somebody that does a lot of presentations over the course of a given year, they're not going to know the sensitivities necessarily of each audience. So give them some feedback in terms of here's what the expectation is, here are the kinds of things that you may want to avoid given this audience. Specify appropriate focus and anything that really should properly be off limits. Important here to include indemnification in our agreement. Again, we're going to talk about that more specifically later, but the idea being if this presenter involves third parties somehow that may make a claim against the content of the presentation or against us for hosting that content, we want that presenter to have to step up and take responsibility for that. Lastly, maybe consider including contractual consequences for breach. Maybe some type of penalty that would be invoked if there's any type of breach of the expectations as far as what the content entails. You could also work that into the negotiation as far as how the payment works, maybe holding back some money to ensure that everything has been performed up to your expectations. Negligence claims, this is the most common type of legal claim there is because it really arises anytime you have an injury that is caused by somebody who's not using sufficient care. That transverses all different types of industries and manifests itself in all kinds of different ways. In the hospitality industry, the important thing that we want to do to manage the potential for negligence claims is to use care in the evaluation and selection of contractors. We want everybody that we're using to be subject to some diligent research on our part to make sure that we're having people in there that aren't likely to cause a problem, okay, that are not known to be troublemakers of any kind. Because if we don't do that, and then there is a problem and it comes out that that should have been a foreseeable situation, we can have a negligence claim that would be easy to establish. We want to insist upon indemnification from any kind of contractor or supplier. If they do something that's going to create a claim, they should be able to stand behind that and provide us with the means by which we are not affected by any kind of claim that they bring upon us. Carefully consider insurance requirements. The indemnification is only as good as the depth of the pocket that we're getting the money from, okay? So if we're concerned about the fact that we may not be dealing with a party that has sufficient resources to offset any kind of a claim that we may have aimed at us, we want to be sure that there is insurance in place, whether our own or the contractors, to cover us in that event. And we want to carefully focus on the types of coverage and the amounts to ensure that we have something that's appropriate in that regard. Shifting gears a little bit here, talking about intellectual property, first copyright, and some misconceptions here, I think. There's a lot of this that is not necessarily intuitive, which is why we want to talk about this a bit. These are the kinds of things people don't often think of until they have a problem, and then it's too late to deal with it at that point. So fundamentally with intellectual property, we want to establish ownership of it so that we know who owns it, and once we know who owns it, then we can get at what kind of rights we need, who has those rights, what ability we have to use the property at issue. We want to get appropriate warranties that anything that we're paying for is going to be free of any type of infringement claim. It's got to be original. It can't be something that belongs to somebody else that would then subject us to liability for its use. And I would say assumptions are dangerous here because, again, some of this is not likely to play out maybe the way that you think it would be. And with that, we're going to go to our first audience question. So grab your little feedback devices there, and we'll go through this short scenario. You hire an individual to develop a website. Your agreement is entirely oral and consists simply of a payment of $5,000 to design the site with your consultation and approval along the way. A couple of years pass, and you determine that you'd like to go a different direction with the site and use a new developer to make some changes to it. You ask the original developer to provide you with the content of the website, and he responds that the content belongs to him and that he will transfer it to you in exchange for an additional $5,000 payment. You file a lawsuit seeking the court to direct the developer to turn over the content to you. Who is likely to prevail? 1, you. 2, he is. Nice job. 11-2. He is. I maybe set that up a little bit. But the answer is he is. And this is something I think that would catch a lot of people that maybe didn't have a notion that this was coming at them by surprise, because the knee-jerk reaction is, but I paid for that, okay? But the answer to there is that's not how it works, okay? So when we go to the next slide, we note that absent a work-for-hire arrangement, the individual that prepares content owns it. Okay, so what's a work-for-hire arrangement? An employee within the scope of his or her employment, we didn't have that in our scenario, or specifically commissioned in writing. Note in the example there, the agreement was entirely oral. Okay, or generally no problem having an oral agreement, but they can be difficult to enforce. But this is an area where if you want to get transfer of copyright, that needs to be in writing. Okay, that also leads us into issues regarding photographs and the use of photographs. This is something that frequently comes up in the hospitality industry. The first thing we want to note about that is, absent any kind of written agreement to the contrary, the taker of the photograph owns the copyright in the photograph. So even if you have a copy of the photograph, you are not authorized to make additional copies of that, to display it publicly, or to make derivative works from it, unless you have a license to do so from the photographer. Okay? Generally, those licenses to do those things are easy to get, but they're going to cost you. Okay? That's where a lot of professional photographers make the bulk of their money, not so much from going out and taking the photographs, but from the sale of the rights to those photographs. The other issue that we run into with photographs is a privacy issue, in that if you've got identifiable people that are in your photographs and you are using those photographs without the consent of those individuals for commercial purposes, they have a potential claim against you, okay, for misappropriation of their likeness in connection with commercial purposes. That is a right of privacy that you have, to have the freedom from people using your image for commercial gain without your consent. So the way to go forward here would be either to make sure that you don't have identifiable individuals in your images. Maybe they're very broad shots with just tons of people and you can't really make them out. The other thing to do would be to get releases from your participants or attendees that permit you to use their photograph. Now, you might think, well, that's not very practical. I'm not just going to walk around with a bunch of sheets of paper and have people read and sign off on stuff. You don't have to handle it that way. Perfect way to handle this would be to do it in the registration form for the event. You put that language in there as part of the terms and conditions of attendance. If you have a way to show that there's been acknowledgement of those conditions, that's going to be sufficient. So that's an easy tip as far as how to deal with that issue. In any event, though, we want to be sure that we've got everything in order as far as assignments and releases go, so that we don't have liability in connection with the use of photos. A written transfer is required as to copyright. If we're adamant about ownership, we want to be sure that we get that in writing and that it's sufficient to convey what it purports to convey. We also want to consider the impact of alternative or to-be-developed formats. There are some court cases a little while back that held that if you didn't specify additional formats, people that assigned works in certain previous formats could go after you for infringement for using them in new formats. The standard workaround for that now is just to say any format now existing or to be developed. That's almost common standard language as far as trying to deal with that issue, but it is something that you want to pay attention to because things evolve over time. And the things that were envisioned years ago are now coming through to where we're going to have some additional uses that we can't even really think of yet in terms of what those are going to be. We want to make sure we've got all of that taken care of. Don't get too hung up on ownership issues. What we want to focus on is whether we have the rights that we need. If we own something, we have all of the rights, but if we only need some of the rights, maybe we enter into a licensing arrangement to get the rights that we need and make that part of the overall negotiation, where maybe we can get some other areas where there may be some flexibility and we'll negotiate on those. It's just common in my experience for people to insist upon ownership when sometimes a license would be sufficient. I would caution you to be flexible on that point. Also, otherwise unenforceable intellectual property claims may be enforced via a contractual agreement. You can use a contract to broaden the scope of your protection as far as what you may be able to claim exclusive rights to, which leads to our next question. You are an event planner who has been asked to produce a high-profile event for a large corporate client. Before discussing the specifics of your vision for the event, your client executes a non-disclosure agreement which specifies that all intellectual property, concepts, and ideas included in material provided to the client are to be owned by you and cannot be used by the client. You then provide the client with a detailed proposal outlining a highly detailed pirate theme for the event. The client declines to use your services and proceeds to produce the event using its own in-house staff. The day after the event, you note via Facebook that it was heavily pirate-themed. You file a lawsuit to enforce your rights under the non-disclosure agreement. Your client argues in response that pirate themes are common and not protectable. Who is likely to prevail? Nice. 10 to 2, you, and you is correct, and that illustrates the last point that I was making, in that this is the kind of scenario that would not generally result in anything enforceable because ideas are not themselves protectable. But what we've done here, though, is by using a non-disclosure agreement, the terms of which expressly broaden what is protected under it, we have now taken something that would not otherwise be protectable in these ideas and concepts and made them the source of a breach of contract claim, which is a very useful way to approach something like this, as between parties if you're concerned about the scope of your rights and what you may be able to do to enlarge the scope of what you may claim as your own. So returning here, we'll speak now, it's still in the copyright area, but more specifically about music for a couple minutes here, and talk specifically about public performance and the different uses of music and the kind of licenses you need. The first thing you would want to do would be to check with the venue that you're having your event at to see what licensing, if any, they have. Many types of venues are licensed for the kind of music that they will have performed in them, so that you might not need anything additional. That would be the first thing to check. Anytime, though, that you have a public performance of music, we're going to need a license, and we're going to need to get that from the performing rights organizations. ASCAP, BMI, and CSAC are the three of those, and they will offer a flat rate for access to their entire catalog based on the type of use you have for music. This is not something you negotiate. These licensing rates are set by the government, and all you need to do is determine what kind of use it is that you're using. You pay the appropriate fee, and then you have the convenient part about this is you have access to the entire catalog. You then don't have to worry about which songs you're playing and what to do on a song-by-song basis as far as that goes. Now, however, synchronizing music with video is a different licensing obligation. Okay? That's not a public performance. That you need a synchronization license for, and that would go as well for plays or other dramatic performances that require what's called a grand license, which would cover not only the music involved, but also the kind of theatrical elements. The bad news about those licenses is, unlike the public performance license, those are not compulsory, which means you're not necessarily entitled to them. So you would need to track down the owner of the rights to be licensed, request either the synchronization or grand license, and then you would negotiate with them on appropriate terms. But the bottom line is they could tell you no, and you would not then have the license. And if you did go forward, you would be setting yourself up for an infringement claim. Shifting gears now fairly substantially, but still within the hospitality realm here, we're going to talk a little bit about some contract issues that come up frequently. And this is always near the top of the list. Force majeure, act of God. This is a contractual principle whereby performance of a contract is excused when something happens that is outside of the control of the parties, that's the key element, that interferes with the performance of that contract. So you could have acts of God, acts of war, strikes, disease. Typically, you're going to look at whatever it is that you might run into in a given location and articulate that so that it's clear that if something arises that's covered by the force majeure provision, that performance is excused. Note that poor business conditions or anything like that is not going to generally be a force majeure situation. That's not looked at as sufficiently in line with something that would prevent performance. Note, however, that typically, if we're dealing with hotels, we get the contract from the hotel, the force majeure provision is going to say that neither party has to perform where doing so would be impossible or illegal. This sets us up for our last question. Your group is scheduled to have an event in Brooklyn, New York on September 12th, 2001. You contact the hotel on the afternoon of September 11th and inform them that you are canceling the agreement. The hotel responds that it remains open and expects the group to honor the terms of its contract. In light of the hotel's response, you proceed to have your event and only fill 10% of your room block. The hotel pursues an attrition claim. In defense, you claim that the attacks of September 11th constitute a force majeure event that excuses performance under the agreement. The relevant language of the force majeure provision specifies that performance under the agreement will be excused where impossible or illegal. Who is likely to prevail? A little split on that one. Answer there would be the hotel, okay? And this illustrates, going back to the slide here, the need for some detailed language on this point. Because if we leave it impossible or illegal, despite the fact that most people would say, well, that's outrageous. Well, is it impossible? No. Hotel's still open. Is it illegal? No. Would be maybe if the facility were within some police tape. But if it's Brooklyn, we can get there. Exceedingly difficult, right? But not impossible or illegal. That's why you want to negotiate this so that you've got the kind of grocery list of things that may occur. Okay, you can have hurricanes or things like that. Certainly if you're meeting in an area where that's at all a possibility. And then some type of catch-all statement. Anything else outside of the control of the parties. And there, you can have substantial negotiation on that, but it's critically important for the reason that you saw from that example. A good idea, too, would be to include a standard of impact in the force majeure provision, which basically says if a certain percentage of our attendees are prohibited from attending, that we can then raise the force majeure provision as an excuse for performance. Typically, that's going to be somewhere along the lines of 30%. But that's also negotiable. We, lastly on that, want to have language in there that says, if we have a force majeure situation and we go forward performing that agreement, that the facility then is not going to come after us in connection with any attrition claims or any other claims based on the reduced size of our event, given the conditions. That's very useful because it does not then force each side into a corner claiming force majeure. You're encouraging cooperation and performance, trying to make the best of a bad situation. In exchange for that, the venue is agreeing, okay, we're going to let you slide a little bit on this because it's better to have something than nothing. That's the thought there. A related issue on this, which is a pretty easy thing to get, but is often overlooked in negotiation, would be to include a provision that deals with the unavailability of a convention center or any other essential facility. If you've got a large meeting and everybody's meeting at the convention center but staying in a dozen hotels around it, in each of those hotel contracts, you want to have a provision in there that says if we are prevented from using the convention center for any reason outside of our control, that we then can cancel those related contracts without liability. If we can't use the convention center, we certainly don't want to be on the hook for all of these various hotel contracts. Usually that's something the hotel will go for. It's not a controversial ask, but you got to think to put it in there because it's not up to them to know where it is that you're meeting and to deal with all the things that you should be thinking through as far as your due diligence on that point. So that's a simple thing, but one that's frequently overlooked. This seems kind of mundane, but it's become a bit of a hot topic lately. Construction. I'm dealing with this more and more, and I'm seeing more and more pushback on this. 10 years ago or more, it was pretty standard just to have a provision in a contract that said, hey, if there's any construction going on, you're going to let us know, and if we, the group, feel at our sole determination that there is a problem that's going to impact our use of the given space, we have the right to cancel without liability. Not so much anymore. Now I'm seeing a lot of language that says the parties will, in essence, agree on what to do if there's construction. I'm not real wild about that if I'm representing the group. Or if they can't agree, then this will be subject to whatever dispute resolution terms are in the contract. We'll talk about dispute resolution there in a few minutes. But we're not seeing the group given such flexibility to determine when it may be able to cancel due to construction. At a minimum, though, we want to have some means of notice so we know what we're getting into. Surprises are really unfortunate in this regard. And then we want to negotiate as much leverage as we can in terms of when we can decide that we're able to cancel our meeting. And we want to have specific representations as far as the projects that are going to be going on so we can get a sense for what the standard of the impact is going to be and whether we may have an issue that may require us to take some action under the contract. All right, I said we'd get to it in a bit. Here we are. Indemnification. We've mentioned this several times, but I wanted to just pull this up so you could actually see what it looks like. This is a standard type of indemnification clause. And you'll note I want to focus on three words here, indemnify, defend, and hold harmless. Those are the things that you want to have in a properly drafted infringement or indemnification provision. Because especially we want to include the word defend so that we have an ongoing obligation to pay the costs of defense. The way that this works, if you have proper indemnification in your agreement and a claim arises under it that's directed at you for the actions of the third party that's indemnifying you, you simply need to provide the third party with notice that there's this claim, you are invoking your right to be indemnified, and from that moment forward, they have an obligation to shoulder the burden of that claim, including costs of defense, which can get extremely expensive. If you don't have an indemnification provision in your agreement, then you're basically on your own. Ultimately, liability may be determined, and you may be off the hook in terms of who is ultimately liable, but you have to pay the cost of defense to get to that point, and that could be a lot of money relatively quickly. So if you don't have an indemnification provision in your contract, you're setting yourself up for that possibility. It's generally a red flag to me if anybody comes back and is hesitant about providing indemnification, because it says basically they're not going to stand behind what it is that they're bringing to the table as far as the contract goes. And they're setting us up for substantial risk in that regard. The only exception to that I would make is that a lot of times municipally owned venues, like convention centers, sometimes there is a state law in place that will prohibit indemnification, so that if you're dealing with the convention center, they might not have flexibility in that regard. That's a substantial consideration, I think, in venue selection. If I can meet somewhere that's going to provide indemnification, I'd rather do that than meet somewhere that won't. Now, sometimes if you need a giant amount of space, maybe the convention center is the only game in town. If not, this is an important issue in terms of risk management and negotiation. Insurance. This was part of our bundle of things we use to manage risk. A couple of things here that we run into pretty frequently. Certificates of insurance. This is just when somebody needs to know whether somebody has insurance and how much and what type of coverage it is. This is something that's easy to get. We just reach out to our insurance provider and say, hey, we need a certificate of insurance to show whoever that we've got this coverage in place. They'll provide that to you. It's evidence that the coverage exists, absent any kind of fraud or anything. It can be relied upon. The downside here, though, is there's nothing binding about it, and it doesn't also have any forward effect. Just because there's coverage in place today doesn't mean that that coverage is in place tomorrow. You could have some issues there, so it's not anything you necessarily want to rely on overly. It's just useful to have information about what kind of coverage is in place at a given time. If we're more concerned, we may want to be an additional insured. That's where we actually get the benefit of somebody else's coverage. So the benefit here is that reinforces and funds the indemnity obligation. Again, we talked with indemnification about how it's only as good as the amount of money that is supporting it. Insurance can help subsidize that if there's any kind of shortage there. It directly pays defense costs. That's very handy because that's where a lot of the expense comes in when you're dealing with claims. And it reduces the impact of loss history on future policies for the additional insured. The idea here is if you're getting those insurance proceeds somewhere else, you're not taxing your own insurance, you're not depleting that coverage and not setting yourself up for the possibility of higher premiums then down the road. The downside of this, in having additional insureds, is that it dilutes the policy limits. If you start adding a lot of folks under that particular umbrella, after a while, there may not be sufficient coverage there, depending on how much you dilute that down. Defense conflicts can get expensive. If you've got a lot of people that are litigating in terms of trying to establish where the liability should be, and they're using insurance money to litigate that could get extremely expensive in a relatively short period of time. And it can also conflict with the contractual indemnity provisions. This is important. If you're indemnifying somebody, make sure that you have the right to do so pursuant to your existing insurance coverage so that you're not setting yourself up for any surprises in that regard. Okay, last thing we're going to talk about here is dispute resolution. Everything that we've talked about so far has been geared toward keeping you out of a situation where you would need any of these choices as far as solving disputes. But sometimes things don't work out that way, and you find yourself in a situation where you have a dispute. You want to look forward to that possibility when you're negotiating your contract and choose appropriate language to reflect your situation. Contracts oftentimes will contain a choice of law and venue provision. That's going to specify which state's law applies and where any claims might be heard. I would say in general, that's not a huge issue if you're dealing domestically as far as determining where something may be heard. In most state laws, in most respects, generally, as far as hospitality contracts go, are quite similar. So that may be something we can negotiate on. You may provide for alternative dispute resolution in your agreement, which would specify some form of either mediation or arbitration. Mediation is a less formal means by which parties resolve disputes. Kind of everybody sits around a table and talks about their feelings and what would be equitable under the situation, and you've got somebody that's skilled to kind of bring the parties together and get them to agree on something. Sometimes that works, sometimes it doesn't. It doesn't hurt to try. The alternative to that, under alternative dispute resolution, would be arbitration, which is more formal. This is in very much respects resembles a traditional litigation situation without the courtroom. Usually it's a retired judge or somebody of that nature that would be serving as an arbitrator. And this then would allow that individual to survey the evidence in front of them and determine who should be liable under a contract. This can get expensive, I would point out. Unlike in a litigation situation, you're paying for the arbitrator's time. You're also paying for the infrastructure of the company that's providing the arbitration services for you. And also can get interesting. I'm dealing with the situation now where if somebody is not engaged and is basically blowing off the arbitration process such that we're going to have to get a ruling in the arbitration and then go into the last option there, which is litigation. So that creates a delay and multiple layers and additional expense if the parties aren't engaged in the arbitration. Litigation, there you're talking about a traditional courtroom type arrangement. That's what applies if you don't have anything else in your agreement. And two, you may end up in litigation as well if you have a ruling on the arbitration then that you need to enforce in the courts. So there are layers to these things. You want to give some consideration as to what's appropriate given the particular context. And know that you've got some choices in that regard. Any questions? Yes.
On the COI form, when you get it filled out, do you have to state each location? So if today I'm at this particular hotel, do we need to put their name on it? And then next week I'm on it at a different location. They asking for it. Do I need to say all that?
If it's a certificate of insurance, that won't be relevant. But if it's additional insured, if you're adding them as an additional insured, I believe you would need to make that distinction. Any other questions?
That's right. There we go. Good.
Yeah.
In the early part, you talked about trying to avoid the situation. Do you have any tools or scales to help, rank things and say, bad place to go?
I would just say use your gut. I had a situation to this point, this is probably about 10 years ago, where my client was going to bring out a keynote speaker, and I can't remember who it was, but somebody of some considerable celebrity on horseback. Yeah, we just looked at that and said, no, that person falls off that horse and is paralyzed, and you have a really substantial situation on your hands. So let's not do that.
So I guess my question is, so the easy ones we can pick. It's the ones that are like, so maybe it's a riding lawnmower, like is that?
Right. And again, I would just encourage you to go through, at the beginning of the presentation, we had, avoid, transfer, insure. Think through all of that. Can you get somebody else to take that on? Can you get sufficient insurance for that? Can maybe a little bit of, from a few of those areas in terms of some thinking about how we can reduce that. But if you trust your gut, though, at the end of the day, know how much risk you are accepting. And acceptance of risk is oftentimes what you have to deal with in a situation where you are in a negotiation, especially with another side that has substantial bargaining power. They may tell you that a lot of their terms are just take it or leave it. And I run into that quite frequently with clients, and I have to tell them, look, this is a real problem, but you do what you need to do. Just know that you're really, exposing yourself here. And you just got to then, use all the resources and knowledge you have to make the best decision. Other questions? Yes.
I've got a question. Probably the most common question we get involved in, or the topic we get involved in as a supplier in the industry, is around the use of an outside AV vendor in a house AV situation. How often do you deal with it, and how do you deal with that? What do you see? I
see it pretty frequently, and it tends, in my experience, to be more negotiable the larger group that you have. When I have smaller groups that come in and want to make changes to that type of arrangement, it doesn't generally go very far. But if I've got a group with some substantial bargaining power, I've seen that type of provision set aside for the benefit of the larger group that wants to come in with their own contractor.
Great.
I have another question. Another question about music, using music.
Yeah.
We've all been in the conditioned place where someone says, that's not been authorized, we have no rights to play it, and the guy goes, just play it, we're fine. And who really? I mean, is it the guy who's playing it? Who's really going to end up being the person that's going to take the hit on that?
Well, it could be several. It could be split between several. You're going to look at who's benefiting from the use of that music. And typically how this would work, for example, in a hotel type setting, the hotel's licensed all the music that's playing in the common areas and the elevators. It's covered in terms of what's happening in the guest rooms and all that. But once you go into the meeting space, you're having a trade show there, you're using music in connection with the trade show, that's generally not going to be within the scope of the hotel's license. So you're going to be on your own for that. And there is for groups, you can get licenses that are calculated on an estimate of like a per attendee type basis, and then you're covered there. But that's oftentimes how this works. And these performing rights societies employ armies of people that go around kind of looking for this stuff. And it's fascinating when you see the court cases on this. It's usually that's like the little guy that just doesn't get it and doesn't think that the rules apply to him, and they'll make examples of those folks. So it's serious stuff. It's expensive, but I would look at it as the cost of doing business, because you don't want to be on the wrong side of something like this. And especially, too, if you're the event planner, you got to know a little bit what's going on here, because this is the kind of thing that people just don't think of. What do you mean I can't put, the Beatles up with this video that I made at this event? Right, exactly. So yeah, those things definitely come up. You want to be aware of it. Oh, good.
Nathan, thank you.
My pleasure. Thanks a lot.
See, one more time around. Thank you again. All right, before we depart, again, thank you for coming so much, for the great turnout, and your participating in today's event. We couldn't be happier. I have some feedback questions for you in helping us do our jobs better with our educational seminars. And if you could just bring up the questions at hand. Okay, so if we conducted educational seminars whenever you preferred, would you want a morning session, afternoon, after working hours, or tell me if time of day does not matter? Very good. Seems like the afternoon works for most everyone. Some morning people out there. That's great. Okay, next question. If we conducted the seminars on the day you preferred, what day would you want them on? I love the countdown clock. Fridays, here we are. We're here on a Friday. Seems like we're working there. Great. Next question. And how about the location of our seminars? Would you want them here in Stage Right, a downtown Chicago location, other, or the location doesn't matter to you? Well, we're evenly matched. The location doesn't matter, and here our building, if we combine those two, it seems we got an answer there. So thank you for the great feedback. And again, thanks for coming out to Stage Right. Thank you very much.